This proposed amendment addresses two circuit conflicts and application issues that have arisen when applying the child pornography guidelines. As I'm sure many of you know, under the Supreme Court's decision in Braxton versus United States, the Commission has the responsibility for resolving circuit conflicts. The Commission's always interested in doing this. They actually can be very hard. There's a reason why the circuits don't agree sometimes. I think Commissioner Friedrich would agree that sometimes they're the hardest issues we hit on conflicting interpretations of the guidelines, but it does lead to disparate calculations for similarly situated defendants. So we are hearing testimony about two such issues. The first involves the vulnerable victim adjustment when the offense involves minors who are unusually young and vulnerable, such as infants and toddlers. And the second involves the application of the tiered distribution enhancement. On the latter issue, the proposed amendment seeks to achieve the appropriate enhancement for offenses involving a peer-to-peer file sharing program or network. So thank you for coming. Our witnesses are Alexandra Gelber, who is Deputy Chief of the Child Exploitation and Obscenity section in the Criminal Division of the Department of Justice. Ms. Gelber works with the U.S. Attorney offices around the country on the investigation and prosecution of federal child exploitation crimes involving cases of child pornography, sex trafficking of minors, sex tourism, enticement, and coercion of minors. Neil Fulton has been the federal public defender for the districts of North Dakota and South Dakota since 2010. He previously served as Chief of Staff to South Dakota Governor Mike Rounds and was in private practice in Pierre, South Dakota, and was a law clerk for our former chair, Diana Murphy. Were you her law clerk when she was here? Could not possibly.
Before.
And the final witness is Mary, no, wait.
You've already introduced me before.
It jumps right over, it isn't. So I'm looking up and I'm seeing you, Mr. Bohlken, who was introduced as part of the last panel. So thank you for coming back to us, the chair of POAG. And our last and final witness on the panel is Mary G. Leary, who is a professor of law at the Catholic University of America in Washington, D.C. You've served as a member of our Victims Advisory group. Thank you very much for your service. Among other things, Professor Leary is a former Assistant U.S. Attorney for the District of Columbia, former Policy Consultant and Deputy Director, Office of Legal Counsel, National Center for Missing and Exploited Children, and the former Director of the National Center for the Prosecution of Child Abuse. You're probably sick of hearing me say it, but of course the red light goes off. I'm polite in the beginning, then I start getting antsy, and then I start saying things. So please keep an eye on that light, and keep your voice up. I mean, I said that last time, but really towards the end, voices dropped again, and people can't hear. There's a lot of background noise here, so please keep your voice up. Ms. Gelber.
Good afternoon, and thank you for the opportunity to discuss the three proposed changes to the child pornography guidelines. Let's start with where we agree. We agree with the proposal to use the vulnerable victim enhancement in cases involving infants and toddlers. For 2G2.2, we agree in concept with the knowing or mens rea element for distribution, and we agree in concept that the defendant should know he was receiving a benefit for his distribution. Where we disagree is with respect to the distribution enhancement in the production guideline. There is no circuit split here. For first-generation distribution, that is, the first instance when child pornography is shared, the enhancement should not be changed. It should apply broadly to those who distribute what they produce, even more broadly than enhancements covering redistribution, to account for the unique and lifelong wound inflicted on these victims. For the rest, our concerns are not with concept, but with execution. The department is especially concerned about the proposed change in the language from if the offense involved to if the defendant. Over our objection, courts could interpret this to mean that these enhancements could no longer be based on conspiratorial or group behavior, conduct the Commission's own report identifies as especially severe. Instead, courts may find that this enhancement would only apply if the defendant personally engaged in the distribution. This would substantially restrict the scope of these enhancements far beyond what is called for to resolve the circuit splits, and would lead to the unintended consequence of reducing the guidelines for the worst offenders who seek and join online groups to collectively share child pornography. As for the +5 enhancement for distribution for a thing of value, the Commission's proposal would reverse settled precedent. The for a specific purpose language would invite litigation as to the application of the enhancement when the defendant had multiple motives for his distribution. The revision would also set the bar so high that this enhancement may not apply to online groups, which often have implicit understandings about the need to share in order to receive benefits. To illustrate this point, consider the following case against 7 defendants currently being prosecuted in the Southern District of Indiana. Defendant Dominique Shaw sent an email to 64 individuals which stated, quote, "I'm pruning out all the dead email addresses and those I never hear from. I know some of you are active and keen to share, and I already have some of your email addresses saved to keep. But I would like anyone that would like to stay in contact / on my mailing list to reply to this email with something hardcore that I haven't sent you. This part is important. This way, I get rid of all the people who are just hovering, waiting for something who I never hear from. And of course, the reason for the hardcore material is to rule out any of you as cops." End quote. As would be required under the proposal, does this email set forth an agreed person-to-person exchange? What agreements have been made among the 64 recipients with each other? What valuable consideration will anyone receive? There are no explicit promises as to what will happen once the others send the hardcore material. The specific purpose of the distribution, according to the writer, is to establish identity, not to add to his collection. The proposed revision is so demanding that it is an open question as to whether the +5 enhancement would apply to this group of defendants who, I should add, regularly shared child pornography via email and online. This group preferred children aged 0 to 3. Shaw's screen name, Neppy, derives from nepiophilia, or a sexual attraction to infants. One member shared a picture of a sonogram describing his plans to abuse the baby once it was born. The goal of any changes to the guidelines cannot be simply to lower the average guideline range. To be effective and meaningful, the guideline must have a proper gradient that treats more serious conduct more seriously. The design of these two proposals, however, could create an inverse gradient so that less serious offenders have a higher guideline range than more serious offenders. This would happen if conspiratorial or group conduct could not be considered when determining if the enhancement should apply. Further, and if I may just briefly make 2 more points, it is absolutely critical that at the end of this amendment process, the distribution enhancements work for all types of child pornography cases, not just peer-to-peer or P2P cases. Because the majority of the cases today involve P2P technology, it is very easy to only consider those fact patterns. But the Commission should not craft these amendments to suit a particular moment in time or a particular technology. We've already heard reference to the +2 for use of computer, which in its day was a useful enhancement. With 1 or 2 technological developments, some of which are already underway, the use of P2P networks to circulate child pornography could effectively end. The guideline must be poised to handle whatever comes next. Thank you. I look forward to answering your questions.
We're a hot bench, so you'll be able to get time.
Well, Madam Chairman, members of the Commission, thank you for the opportunity. And I think it's important as we start today to look at these proposed amendments to resolve circuit splits through the lens of the experience of this guideline. And as the Commission knows well, this is a guideline that, since you reported to Congress last in 2012, has been recognized by many people as not working. In 60% of the cases under 2G 2.1, the production guideline, judges are going below the guidelines. In 66% of the cases under 2G 2.2, the trafficking, which would be receipt, distribution, possession guideline, judges are going below the guidelines. That's without government motion. That's just judges going below the guidelines. So the guideline as it sits today isn't working, isn't being accepted. So we would ask the Commission, as you resolve the splits, to keep that in mind and look at a resolution that simplifies operation of the guidelines, that rather than expanding that divergence between those few cases where the guidelines are being accepted and the vast majority where variances are being given, that it work to bring those bands closer together and down. To talk briefly about the specific proposals, the vulnerable victim enhancement, we believe, would effectively become another almost automatic enhancement, like the computer, like the image enhancement. Under the proposal, it would essentially make age for children of a certain age an automatic enhancement. Age is already factored into the guideline as an enhancement. If you look at most cases, the S&M and violence enhancement applies to most instances involving a sex act involving small children. So age is built in a couple of times. And again, in 2010, the production guideline, judges were going below 45% of the cases. In 2014, they were going below in 60% of the cases. The guideline is being less accepted, not more. In distribution in 2010, it was 55. In 2014, it was 66% of the cases where judges were going below. It's getting less accepted, not more. And I think perhaps most telling, in 2014, the number of upward variances or departures was less than 3%. So the experience on the ground is not one that judges are finding the guideline is inadequate to what they're doing. They're finding it's vastly more than adequate. I think, too, when you look at the circuit splits, if you go to the 9th and the 5th Circuit where these two issues come from, and you start to break it down at the district court level, you find disparity that already significantly exists in this problem. In the 9th Circuit and the 5th Circuit both, more than 50% of the district courts that had dealt with this issue had never applied the vulnerable victim enhancement. The range in the 9th Circuit was 4.4% of the cases to 17.8% of the cases in the districts that had ever applied it. It was 4.9 to 12.7 in the 5th for those districts that had applied it. The point in throwing the numbers out there is simply that this is a problem that is relatively isolated and contained right now, and our concern is that by adopting the proposal on vulnerable victim, it metastasizes across the country and throughout the guidelines. We think a better approach would be to stick with the existing language and clarify that age is already accounted for and that vulnerable victims shouldn't pile on top of it. To turn to 2G 2.2 on the distribution, I'd like to just briefly talk about that through the lens of the example of a client of my office. I'm going to refer to this individual as Greg. Greg was, at the time we tried his case, 20 years old. He had never lived independently from his parents. He had never dated. We learned in a psychosexual evaluation that was ordered for sentencing by the sentencing judge. He had undergone special programming in school, and he eventually moved out of that and back into general school, but he never thrived. He was tried for distribution, receipt, and possession. He was acquitted by the jury of distribution and receipt and sentenced only for the possession count. The fight at sentencing came down to whether the 5-level enhancement or the 2-level enhancement should apply for a peer-to-peer. We had expert testimony in that instance from a forensic computer expert who looked at his download history. He found that Greg had begun using a peer-to-peer network to obtain porn, adult illicit porn. Might not be tasteful, but it's legal. From that point, in doing generalized search for the words porn, he found child porn. There were 5 downloads from FrostWire in a less than 30-day period where all of the images came onto his computer. Less than 1% of them were child porn. When he was asked by officers about his download history, they said, well, isn't there a torrent on your computer? He said, what's a torrent? He was not a sophisticated user. This was a program that we can talk about more that mandated sharing. He was not a knowing user, and he's an example of why it is necessary to have knowledge as a component to distinguish among those people who are purposely distributing, who are more culpable distributors, and the vast majority of folks who are generalized peer-to-peer users. Thank you.
Thank you. Mr. Bohlken?
Thank you again, Commission, for having me here today and giving me the opportunity to speak on this proposed amendment. To take up where my co-panelist left off, we kind of agreed with the knowingly, and I know I'm going backwards from the amendment, but we agreed with the knowingly requirement being added to the 2G 2.1B3 and the 2.2B3, because we do think that some of the programs that are out there today and the data dumps and stuff like that, programs are automatically sharing whenever they send one of those programs or receive, they're automatically sharing. So we agreed with the knowingly requirement being applied. We also agreed with the proposed change to the B3B, which created a higher standard for the SOC for distribution for the receipt or expectation of receipt of something of value, not for pecuniary gain. We believe that the investigators are generally discovering evidence during their interviews or financial computer analysis when the defendants are engaging in some sort of quid pro quo exchanges involving child pornography. And we think this change will help with consistency across the country in reducing the application of B3B enhancements for the use of peer-to-peer file sharing without creating the need for a bright line rule regarding file sharing programs and such. On the application note for vulnerable victim being included in all three of the child porn guidelines, when we talked about this, it is currently being applied differently across the country. One circuit rep applies it frequently, and she was in the 5th Circuit. She was aware of it. The rest of the circuit reps very infrequently have ever seen it applied. But we did feel like the application note would bring consistency across the board on how that is applied. And it makes sense in the 2G 2.1 and the 2G 2.6 guidelines given the severity of those offenses. And in the 2.1 guideline, the defendants generally have contact with their victims. They know the age, relative age of the victim, so they have firsthand knowledge. The one addition that we were kind of hung up on was with regard to the 2.2, 2G 2.2 guideline, and we discussed complications with the application note being included there. Because the defendants in that guideline don't always typically have contact with the individuals that are in the images. Secondly, the possession defendants often get large volumes of images in what are called data dumps containing a wide variety of images or videos for which they're accountable for, and they may not even have requested that age group or even viewed the contents of all the different images that are on that file. And thirdly, there's cases where evidence reflects that possession defendants have actively sought the actual toddler or infant on the images, and we believe those are the people that should be more targeted by this using the Chapter 3 enhancement in addition to the age enhancement within the guideline. One of we discussed the terms that were used in the synopsis of the proposed amendments, and instead of using the term extreme youth or small physical size. We thought the more specific term that was used in the synopsis of the proposed amendment, that being infant or toddler, while still not perfect, was a better use. Using those terms was better than the extreme youth and physical size. Thank you.
Thank you.
Good afternoon, members of the Commission. I'd like to thank you for holding these hearings and for inviting the Victim Advisory Group to share the perspective of victims in what we refer to as child sexual abuse images. As this Commission knows, the preferred term, and a number of courts are going to it. As to the first point involving unusually young and vulnerable minors, we'll rest on our written testimony as we agree with the proposed changes in that because these children are uniquely unable to defend themselves, report the crime, and even identify the crime. Turning to the two-level distribution enhancement, the Victim Advisory Group strongly opposes the proposed amendment to the guidelines and to insert the term knowingly in these provisions. And I should note at this juncture that our objection is to that language in B3F of both 2G 2.1 and 2G 2.2, and the extent that our written testimony reflected just 2B 2.2, I want to be clear that it's to both. We have two main reasons. One is the reality of the peer-to-peer network file sharing as a massive distribution mechanism that requires affirmative participation by offenders, and two, the proposed amendment also fails to reflect the resulting compounded harm to a victim when peer-to-peer networks are used in the circulation of these images. For purposes of time, perhaps it would be just best to refer back to the Commission's own statements in 2012 in their report, where it says quite directly, the very existence and purpose of peer-to-peer networks is to share digital content. These offenders choose this way to distribute these images as opposed to other ways of doing so. As a result, victims are more extremely hurt. As a result, these are traded on a massive platform, and their images are injected to an electronic stream where they will exist in perpetuity. The attraction of the peer-to-peer networks for offenders is that it offers the best of both worlds. The ability to be a part of a community, not only that they can exchange their images, but that they can receive affirmance for their criminal activities and proclivities. But secondly, they can obtain a large amount of child abuse images through a decentralized system, which gives them anonymity and decreased risk. But impersonal distribution should not be confused with the lack of knowing distribution. And just because it's impersonal does not mean that it is any less damaging to the victims or that it is any less harmful. A second reason to follow the lead of a number of these circuits is that victims' images, the victims are more severely hurt when they are shared in this peer-to-peer context. The choice to share via peer-to-peer, as opposed to some other method, is a choice to support a marketplace that demands the production of more images, thus increasing the risk of victimization. And it's the choice to be a part of a community that affirms this value system. This amendment really turns a system, I would suggest, our sentencing system on its head. If adopted as proposed, if a defendant were to hand one photograph to the person next to him and say, hey, look at that, it would seemingly apply, it would meet this knowing standard. However, if a defendant seeks out and joins a large child pornography community for the very purpose of obtaining and sharing massive amounts of child pornography, and risking that the victimization will continue for eternity for these victims, that defendant wouldn't necessarily get the enhancement. With regard to the 5-level distribution enhancement, the Victim Advisory Group also strongly opposes that proposed change. The proposed amendment is far too narrow, and it changes the meaning of the guideline and fails to account for the additional harm to the victims as well. The reality is that in the wake of the internet, the barter system is responsible for much of the trade of child abuse images and is often done with people unknown to the defendant as part of a larger system. Thus, there is rarely the specific agreement with the terms laid out to the level of detail and the language that the language seems to require. Secondly, the proposed amendment requires that the item of value the defendant expects to come from that person. Thus, it would arguably not apply in an instance where an offender produces images to an individual in order to gain access to a group of child pornography traders, because they're not necessarily getting the quid pro quo from that individual with whom they distributed the image. Secondly, when a victim's image is used to obtain other images, the victim suffers additional harm that should be accounted for at sentencing. It's axiomatic. It's terrible to be a victim of a child sex abuse crime, of course. It's terrible to have that memorialized in eternity. It's terrible and compounded to have that distributed throughout the world. But it is compounded even more when those images are used as currency. And as the District of Massachusetts noted, this is another layer of exploitation felt by the victim, because it gives her, quote, the indelible knowledge that not only will her images be reviewed in perpetuity, but that they will be utilized as currency to further victimize other children. I see my time has expired, so I welcome your questions. Thank you very much.
Thank you. I was going to start off with asking the Department of Justice. I've been a judge for a long time, and I get a lot of these cases, and I've never seen it charged as a conspiracy. It's usually an individual distribution or receipt count. So I'm trying to understand your concern that you've articulated that somehow the amendment would interfere with your conspiracy prosecutions.
I can't speak to what you may have seen in terms of the prosecutions that are brought in your district, but in my office, it's very common for us to bring large conspiracy cases. We most frequently indict these under the Child Exploitation Enterprise Statute, and we always have several of these cases going at any given time. For example, there was a case it was Nebraska, not the Dakotas. I'm sorry, there was a case.
No, it's west of
I know it wasn't, because we've never seen a conspiracy.
It was called. There was a case prosecuted in the District of Nebraska. There were 28 defendants. 20 were ultimately identified enough for arrest. 19 of them have been convicted. The case I referred to in the Southern District of Indiana, which is also a conspiracy case against the 7 defendants.
How many would you say there are a year?
I think we could check that data and get back to you.
Less than 12?
I wouldn't want to answer off the top of my head.
So the question is, in the typical case, with our, I understand let me just say, in your case, in the conspiracy case, how does the amendment hurt you? Because you have to have shared intent, right, to be convicted.
Our concern is that if you change the specific offense characteristic from if the offense involved to if the defendant, that would impact our ability to bring in evidence under relevant conduct under the jointly undertaken criminal enterprise theory. That's our concern. That if you have 20 or 30, there was a case in the Western District of Louisiana involving 70 defendants where that were all part of a group, that it would focus exclusively on what the individual defendant did and not his role in the larger community.
I had the same question about this. I don't see how that's not my intent or how I'm personally, just me speaking for myself, thinking about was this would not change anything related to conspiracy law. It would just change the definition for a particular offender. And then if anyone else was in a conspiracy to help achieve that result, they would still be held responsible like they always are under our relevant conduct and jointly undertaken rules. And so I guess I wasn't sure why you thought the wording change would have that effect, just because the particular target crime speaks about what kind of mens rea or whatnot a defendant needed. That wouldn't change anything about conspiracy mens rea or conspiracy requirements.
Well, this may be impolitic, and forgive me if it is, but then I don't understand the point of changing it from if the offense evolved to if the defendant. I assume by proposing that change that it's meant to change something.
Well, in any case where there was an individual being prosecuted who's not part of a conspiracy, you'd have to show that that person had knowledge, but you wouldn't change if there was someone else who wanted to also further that crime by taking part in the activity. I mean, that was my understanding, and maybe I'm misunderstanding how the circuit splits developed in these cases, but in an individual prosecution, wouldn't it change the law in those cases?
I'm terribly, I don't follow your question. I'm sorry, I got lost in it.
Well, you were saying it's a meaningless, what we've done here is meaningless.
No. Let me be clear. I'm just talking about the change of the focus from the offense to the defendant.
Right, so this is in 2G, 2.
This is for all of
all of them.
Yes.
So wouldn't it be changing or clarifying, I guess is maybe the better way to put it, in jurisdictions that were confused about what it requires, that you'd have to show you had a defendant who knowingly distributed. And let's say that was the only person being charged was that defendant. From now on, it would put the burden on the government to show that the defendant knew, for example,
Right.
this was a program that distributed. So that would be the change.
Okay.
But it wouldn't change anything that had to do with whether or not there was a conspiracy around that particular defendant engaging. So let's say this defendant said, and 3 of his friends, they say, we'd love to help you. No, we know you're going to distribute this. How
Right.
can we help you? It wouldn't change anything about that scenario.
I think it wouldn't intend to make that change, but as we say in our comments, we fear that it makes it vulnerable to such an interpretation. That's why we agree that the distribution enhancements should be changed to incorporate a mens rea element. We propose doing that by adding it to the definition of distribution in the application note, so it's clear that that any distribution has to be done knowingly. And we propose that as an alternative because then it doesn't create this question as to whether the scope of conduct has changed. So our counter proposal, we think, achieves the goal and it resolves the circuit split without introducing this potential vulnerability.
By the way, those jurisdictions weren't necessarily confused.
Right. They
They
were
were just reading the
following.
plain
Yes,
text.
exactly.
Of the guidelines.
Correct. To clarify what the, yes.
In fact, someone from one of those jurisdictions might even support the clarification.
Well, I mean, if you look at the cases that found a strict liability application, they said, well, the guideline doesn't say it's required. So, I mean, so if you add it in, it takes care of
So
it.
you agree there should be a mens rea. You're just worried that courts are going to improperly apply this guideline if we draft it the way we've proposed. You
I
like
don't-
your approach better. But substantively, you're on the same page.
Yes, as I said, we agree in concept, but not in execution. We think our proposal, and we actually offer 2. One is to add it to the definition of distribution in the application note, and the other is to add knowing or reckless to the introductory language to the specific offense characteristic, that this accomplishes the goal without introducing the litigation vulnerability that we've identified.
I like the proposal, or at least to think about the proposal adding reckless. I was wondering if anyone else wanted to comment on that. Yeah.
I certainly would, Madam Chairman. I mean, I think it becomes very important to some degree get down in the weeds on this, because when we talk about how child porn is moving right now and how it is being obtained, I mean, we say peer-to-peer as though that is one monolithic thing. It's 74% of the receipt cases, it's 85% of the distribution cases. It is how child porn is moving, period. But within that realm, I mean, there are very different levels of users. There are peer-to-peer networks that are moderated, that are user protected, where you have to obtain admission, where you purposefully seek it out, you ask to be let in, and the keeper of the club lets you in. There are also P2P networks like FrostWire, LimeWire, and Aries, like we talked about, that was used in my client's case, where there is no they to let you in. It is an open source program out there that has, again, licit uses. There are totally licit music files on there. There are video files on there that are licit. There are licit adult porn files that are on there. And there's also child porn. There are people who go onto those peer-to-peer networks and search terms like preteen hardcore. They're looking for a very specific thing. There are also people who go on there and search porn. I would analogize it to the very homespun example. If I walk into the grocery store and say, I want a high-fiber muesli to my grocer, or I say I want cereal, I am casting a very different net. And our point on this is, if you don't interject knowingly in mens rea in this net just sweeps up everyone, because Greg, as an example, again, searched the terms porn. And he got 167,000 files. And that is not an isolated example.
So you're saying that would be the difference between knowing and reckless. He didn't know he was going to get the child porn, so if we had knowing, you wouldn't be attributed to it. He said reckless, you should have known that if you put in porn, you were going to pick up the kiddie porn.
What I think I'm saying, Madam Chairman, is that to draw a meaningful distinction among the levels of culpability on this front, you should really think about three groups of people. The people who are doing what I would think of as a 5-level enhancement, the old first-year contracts, bargain for exchange. I offer you porn or ask for porn, I give you some valuable consideration back, and that's 5 levels. The 2-level people who are knowingly pushing porn out into the world, either because they produced an image and shove it out, or because they knowingly enter a peer-to-peer to share, which again, remember, you have to know how a peer-to-peer network works. If you use FrostWire like our client did, there is a 9 window, not just clicks, 9 windows you have to go through to disable that program's sharing. When you set it up, it sets up a shared file and automatically downloads the images into the shared file. Some programs automatically upload, including partial images, meaning you can be distributing child porn before you have a complete child porn file, or no, you do. And then there are the people like Greg, who I would say are unsophisticated users, who ultimately do move child porn back out distributing because of how the program works, but they're not intending to. And our concern with reckless is you still sweep those people up. So we think you should have 3 bands of culpability: the people who are bargain for exchange, the people who are knowingly pushing it, and the people who are getting swept up into that because of how that system works. How you smith that language rests with you, but I think that's where the bands lie.
First time ever I heard about the situation where some people are bargaining for faster speeds. It's whether that should be considered something for value. In other words, you agreed for the distribution in exchange for a faster download. Is that it? So how frequent is that? Is that a serious concern for us to think about in how we word this?
Well, I think it's a little bit difficult to assess how frequent it is because there's a circuit split. So we don't know in the circuits where they don't require specific evidence of knowledge. It's hard to capture how many cases this evidence isn't presented in those circuits because it's not necessary to do so. What I would say with respect to faster download speeds, we would urge the Commission not to reverse the settled precedent in this area. And it's very easy to think, faster download speeds, why should we account for that? But I think it's important to finish the sentence. It's faster download speeds in order to obtain more child pornography more quickly. Faster download speeds is a tool of the crime that augments the extent to which that crime is committed. It's like buying more ammunition. So it's not just some sort of ancillary benefit, like my computer's going to run faster. It is intimately connected to the very commission of the crime, and that's why it's entirely appropriate to leave the settled precedent in place that in cases where there's evidence that the defendant knew that by distributing he would receive that benefit.
Well, I wonder, I was intrigued by your remark about making sure that whatever we do, we take into account that technology can change, and you cited as an example the enhancement, as I understood your testimony, the enhancement for use of a computer, which is the 2-point enhancement. So is it the Justice Department's position that we ought to do something about that?
Well, yes. I mean, the department is on, you mean with respect to use of computer?
Right.
Yes.
Since it's clearly the heartland of cases.
Yes. The department is on record on that. Following the Commission's report in 2012, the department issued a written response to it, and in that outlines a number of changes that we recommend to the guidelines, and one of them, even though the Commission did account for the fact that would apply all the time by lowering the base offense level. It's kind of like a human appendix, and they're more meaneful.
Of course, I wonder, for example, I just saw that there's a proposal for Google in San Francisco to install the highest speed, free
Yes.
Internet connections and put in a whole new fiber and so forth, and give it to everybody in the city. So I just have to wonder, when we start marrying criminal enhancements to changes of technology, whether we're just going to walk ourselves into another situation of where it's in a year, 2 years, it's going to be totally inappropriate.
I would absolutely agree. I absolutely agree with that. As I said in my opening statements, that is a big concern. If you start talking about, and that's frankly one of the reasons why we respectfully disagree with the suggestion to include a bright line rule that courts cannot consider the use of a peer-to-peer program in deciding whether these enhancements should apply. Peer-to-peer programs, there are many different kinds. They have many different features. They're changing every day. It is a piece of evidence, and the courts should be left to assign whatever value and make any interpretation from that evidence that they deem appropriate. But making a statement about the evidentiary value of peer-to-peer programs when you don't know what they're going to look like tomorrow, I think could be quite a mistake.
Ms. Leary?
Thank you. Just a reference to the analogy about buying the cereal or whatever, or things. I think a better analogy might be to look at the distributor, and as the court did in United States versus Schaefer, talked about the self-serve gas station. And there, we say just because the distributor doesn't know the exact person or doesn't know the exact transaction, doesn't mean that any less they're not distributing gasoline. And this is really a time framing issue with regard to peer-to-peer. If we focus on that very moment and getting down into the weeds, there may be issues about that specific transaction. But if we open up the time framing, at some point these offenders decide, I want to get my child pornography, and I, therefore, am going to download this, and I'm going to go through these 9 screens or not. But when we open up that time framing, we've seen this as a series of affirmative decisions on the part of these offenders. And while we would prefer not reckless or knowing, reckless is certainly better than knowing, because knowing is really artificial.
May I just briefly, Madam Chairman, that's not right. I mean, if you look at how the peer-to-peer are working, you have to opt out in many of these instances. Many of the programs, if you have opt out, when you reboot or start the computer, they change your preferences back to the sharing mode. You see that by looking at the fact in our comments, Ivy League institutions full of reasonably smart folks are in their IT protocols telling people about this risk of P2P programs because you don't know it. So to say that people are consciously choosing just because you use a P2P is not right. There are people.
That's not what I said.
Aren't. I didn't say Ms. Leary just did.
Okay.
And we can get a factual dispute. I would defer to this commission's 2012 report, which discusses the different approaches.
Thank you.
Question just about the language of the extra vulnerable victim. So you had suggested, Mr. Bohlken, that we might be better off saying infant and toddler, and I was just curious if the rest of the panelists had a view on the phrasing of that particular provision. Right now, I don't have it, how we phrase it is, if the minor's extreme youth and small physical size made the minor especially vulnerable compared to most minors under the age of 12, and the defendant knew or should have known this, apply this. And the question is, would that be better stated as infants and toddlers?
From the position of the Victim Advisory Group, and we agree with, I think Mr. Bohlken very wisely said, neither of these is perfect, and I think we would certainly agree with that. But from our perspective, I think the proposed language would be a little bit superior. I mean, the question is this a relevant consideration for a trial, for a sentencing judge, to look at the seriousness of the offense, and just punishment, adequate deterrence? And I think the broader language would more give the sentencing court that flexibility to be able to do it rather than getting in a debate about what's an infant, what's a toddler. But
I worry about it a little bit, though, if you say, every 7-year-old is little. I mean, on the scale of things, so how little is little before you add it? Whereas infant and toddler, it's horrifying. They're taking kids who can't really talk or complain or protest. So infant and toddler catches. We originally started off there. We've gone back and forth on it, so we were sort of thinking that we weren't sure what the right wording was. So what do you think?
I think I could make arguments that there's definitely something appealing to infants and toddlers because it's plain language, it's words that everyone understands. My one concern with that is that sometimes the images are of such close-up that all you really see are, like, for example, are hips, and you have to make a relative comparison of the size of the child relative to the adult. So in that situation, having something like extremely small size would provide a little bit more flexibility in those scenarios. The one thing we would recommend with respect to 3A 1.1, just adding something that says except as otherwise provided in the guidelines, so it's clear that the two, in the application note, so that it's clear that everything should be read together.
So for the three of you who support the infant-toddler change, do you all agree that if the commission's going to do it, it's got to do more than just solve the circuit conflict, that we need to make this correction in the production and the child exploitation guidelines as well? Mr. Bohlken, you say you have concerns about it in the distribution because sometimes these come in mass, and you feel more comfortable if the defendant actually knew that in that bulk, that big download actually knew about the infant and toddler. Did I understand you right?
Yeah, but for consistency, we did agree that the application note should be in all three guidelines, but we did have additional discussions in the 2G 2.2 guideline, because for some of the same reasons Mr. Fulton was talking about, the different type of offender.
So we should say that they knew there were infants and toddlers in there.
But not for production and exploitation.
Right.
You're talking about for distribution.
Right.
But my question is, if we're going to do this, and I'm not sure we should, but if we're going to do this, are we better off just addressing this in 3A 1.1? I mean, I haven't thought of all the possibilities, but the initial commission who created this guideline made pretty clear that if you've got an age enhancement, you shouldn't have the vulnerable victim enhancement. Now, maybe they didn't foresee that child pornography offenses and child exploitation offenses one day would involve infants and toddlers, but there's a pretty clear policy decision in 3A 1.1, and I just throw out, is it time to revisit that? If we're doing more than solve this circuit conflict to do this in a logical way, do we need to go so far as look at that across the guidelines if we're really going to delve into this?
Well, I think what we would say is what matters to us most is outcome. So we support the some sort of recognition in the guidelines in cases where the defendant knows or should have known it involves infant and toddlers. It's important to keep in mind that having a mens rea element here distinguishes this from the other content enhancements. So the prepubescent and S&M can be strict liability. This one would not be. It would therefore not apply in cases where there was a large data dump unless there was some sort of evidence that the defendant was aware of that specific image. So we are more interested in outcome on this one than in structure. So if it's an additional +2 in the SOC, so it doesn't invite these questions about the policy of the vulnerable victim enhancement, we would defer to you on that one, as long as the concept is reflected somewhere.
One more point I wanted to make about the application note being in all three guidelines. We kind of looked at this and talked about the computer enhancement and how when that was first written in, it wasn't applicable in every single case, and now it's become it's applied in every single case. I can remember the days when child porn defendants actually got the stuff in the mailbox, but we've moved way past that. We believe that with this application note, that it's going to be applied in almost every case now. So it's going to make the guideline ranges go even higher, and the circuits that vary or depart as a practice are going to continue to do that, and the circuits
have a wider non-compliance.
Exactly. I mean, there could be you could maybe distinguish, because I know some of the circuit split was, the age, taking the age alone doesn't necessarily identify these like super vulnerable victims, the toddlers or something. I had thought that there could also an alternative could be maybe do a 4-level increase for a toddler or an infant instead of just someone under the age of 12.
Yeah, Mr. Bohlken, do you ever find courts avoid this issue by simply saying, I'm going to depart in this case?
Yes.
Based on the infant toddler? Have you seen that? Is that happening? Or is it always that they engage on this particular guideline?
I think from my personal experience with this guideline, that the trouble I think a lot of courts have is that the guideline ranges have become way too high. And I also have seen firsthand that judges kind of like to look at hands-on sex offenses and child porn sex offenses and see which ones are being punished more severely by the guideline.
For example, in a production case where it might have actually involved a toddler or infant the defendant interacted with. In your experience, is that the kind of case where a judge is going to depart upwards, despite the lack of application of the vulnerable victim enhancement?
Currently?
Yes.
Currently, I haven't seen an upward departure or an upward variance in a child porn case.
No,
I would say they would sentence within the guideline
or
range.
exploitation. I mean,
I would say within guideline range for something like that has an aggravated factor, like there was several toddlers or infants involved. I would say where that's not a typical case where they go down or very downward, it's a within guideline range sentence.
Wow. All right. So, anything else? Anybody has questions? Thank you very much. Very interesting and important area. Thank you. Stand in recess, I suppose. Adjourn. That's it.